Okay, good afternoon. This is Curt Verone,
And this is Brad Pinsky.
and we're here for another edition of Fire Law Roundup for April 10th of 2023. Brad, go ahead.
Well, first of all, let's just mention that, hey, a milestone. We've hit 1,000 subscribers, so that's pretty good. If we could get 1,000 more, I'd be really excited.
Well, yeah, and we need, it's funny now, I kind of feel like YouTube sometimes kind of moves the goal line for us. And originally we had to get 400 subscribers. Now it's 1,000. Now we're about 700 hours short. We've got to get 4,000 hours for the year. So we need about 700 more hours. So that would be 700 people watching for one more hour or 100 people watching for 7 hours, but we got to get somehow 700 more hours. So I know my dad's going to put in some extra time rewatching some of them, and hopefully we'll
keep producing more content and people can keep watching.
Well, and that's it. And I think what's the benefit to the folks who are thinking about it and our regular attendees is that once we hit that benchmark, we're going to be able to do a lot more. First of all, YouTube expands our reach. Once you hit that plateau, you're officially an influencer. And so that's sort of number one. And we will be able to devote more time to it. And Brad, one of the things I really would like to do is start interviewing some of the people that are involved in the lawsuits. And I've done it from time to time. But I think what we like to do, what my plan would be, is for me to interview one side, you interview the other side. And, I think it would make for a more balanced approach to some of these things, because sometimes we only know one side of it. And I think, the fire service would benefit from hearing from both sides. So
yeah, absolutely.
That's what I'd like to see, if in a perfect world, I guess. So, all right, well, let's go.
Right, let's start to, let's head out to Oregon. Why not? Like the Ducks, I'm a big fan. So here we have just a lawsuit. We don't know anything about it. And it's funny because it's kind of a bread and butter lawsuit, as I would say, right? We have two female members of the Oregon Fire District. They're laid off in February of 23. This is pretty recent. They've now filed suit. And what they're doing is they're claiming that the lawsuit they're claiming they were laid off for retaliation for complaints they had made about sexual harassment on the one hand and financial mismanagement, which is interesting because they allege that, they made these complaints that were not investigated or they were labeled as unsubstantiated. Now, just as a point to everybody, never put yourself right in the position of not investigating a complaint. If you investigate and you made a fair investigation, regardless of the outcome, in my opinion, you're like 90% the way home. But if you don't investigate, you're like one step away from losing anything against you. You got to investigate, and it's got to be fair. So the other side, or the other part, they say is, well, they investigated and they found it unsubstantiated. Okay, well, of course, the employer is investigating kind of themselves. That may have happened. But here, what they said is financial irregularities kind of prompted these two females to raise additional concerns. They said those concerns were also ignored. And in January of 23, the district reported that the finances were in bad shape. And they accused, allegedly, their previous financial director and finance manager of mismanagement. And as a result, they lay off two staff members. Well,
and guess who?
Right. So I think, look, and here clearly they have made, because we're going to talk about, again, the shifting burden balancing task to McDonnell Douglas. But again, here, the other side is going to get to come back and say, look, we've evaluated positions. We needed to get rid of two. Now, if there are 10 they could have gotten rid of, and these two women who are the only two who made complaints are the only two who went, it could look bad. We don't know anything of that, right? We're not even going to guess, but that will be interesting to see the answer, to see what they say about their legitimate reason for terminating these people. Because normally, to give credit, I hoping that most people aren't insane enough, most employers aren't insane enough to think that simply eliminating a position or downsizing a position that only involves two people who happen to complain. I have a hard time believing they would do that. Not that we haven't seen that, but generally you think that's not going to happen. So let's see what happens.
Yeah, well, it's funny. Our friend Brian Massat, who helps teach the FLSA class for us, has a really good way of cross-examining people for retaliation, and it goes. It's really brilliant. It goes something like this: you put the chief on the stand and said, "Chief, you were aware that they filed complaints. Is that correct? Okay, all right. And you don't have dementia, do you? You know, you don't have Alzheimer's or anything. So, okay, so that when you chose to lay them off, you didn't have dementia, right? You didn't forget about the fact that they had filed complaints, right? So it was in your head when you decided to lay them off. It was in your head that they had filed complaints. You didn't forget, right? And it's a brilliant line of cross-examination. And it's, you know, what do you say? Yes, I got dementia, or well, I wasn't thinking about that. Well, it was in your head, right? You don't have dementia.
Right.
So.
And I got to tell you, you know, based on that, I have said, God, it's probably a long time ago. So I had that situation where Chief said, you know, I got these people, but they got to go anyway. And it was totally legit. Mm-hmm. And it was on the, I guess the same topic of eliminating a position. And they had several they could eliminate. And everyone agreed, you know, getting rid of this person, nobody would mind. So why not? All things being equal, they said, you know, listen, we can get rid of any of them. All things being equal, let's just get rid of the one who complained. I said, you can't do that. Right. But so what I recommended, and they did do, and it avoided a lawsuit, I think, was we brought in a independent, neutral third party with PA, had them do the evaluation, gave them a specific letter, which never mentioned anything, told them there'll be no interviews. So you can't get any other information outside the four corners of this paper. That paper never mentioned anything about complaints, and they came to the same conclusion about what position should be eliminated. And I think that suggestion avoided the lawsuit.
That's an excellent way. I never heard of doing something like that. That's an excellent way.
Everyone was biased. I couldn't come up with any way to keep it out of their heads that, well, but you still knew they complained.
I understand, and I may misspeak this a little bit, but I understand FDNY now has a process at their academy. And they have a panel, a racially balanced, gender balanced panel that will, when they have a candidate, a probie, or someone in the, I don't even, what are they? Probie is once you're out of the academy. So whatever you are in the
candidate, yeah.
You know, if you flunk this, you flunk that, you can't do this, you can't do that. That information goes to this racially gender balanced panel, and they look at it without names, without any qualifying information. And they say, give them another chance, or no, that's it. Right. And I think that's really a way to sort of say, look, this had nothing to do with whatever else was going on. It's not, you know, in this case, the fact that you complained, or your race, your gender, your age, your military service, and disability, or whatever it may be. Yeah.
And what I like about it is, it's kind of the law school exam approach. For lawyers know, most law school exams don't have your name on it. You're a number. So they can't take into consideration anything but what's on the paper. And frankly, that's where I stole it from way back, is put them in the position of not being able to take any facts other than what's on the paper. And then there's no question of what they considered or didn't consider. But, you know, it costs money. It probably costs $10,000, $15,000 to go through that, but it was a lot cheaper than the lawsuit.
Absolutely. So, absolutely.
Wow. All right. You and I have a great talent of turning a little short story into a whole.
Yeah, that was going to be a short one, right?
Yeah, sure. Yeah. It's famous last words. Okay. Now let's go to Miami-Dade. This is, look, this is a good example of a department taking something seriously. This is, unsettling, but somebody put a camera in the bathroom that faces towards the shower. They're investigating. There's a criminal and administrative investigation. And what can you say other than it's, you know, tough, but look, they're going to find it. And I know how they're going to find it because I've been involved with this a number of times. They're going to find where the IP address went back to. This is going to be over in 1 hour after they get either subpoena results, and more than likely, here's how stupid people are. More than likely, they're using the station's Wi-Fi. And so they're immediately going to find out where this is. I could do that in less than about 10 minutes. It's a free program. You just put it on your computer and you can see everything accessing your Wi-Fi and the IP address it's using and sending to. So anybody who's logging in to view on that Wi-Fi you're going to see them. And whoever did this is an idiot, and nonetheless disgusting.
Well,
but
I wish this was an isolated case, but I've probably got about 20 different cases, identical facts, across the country. And, voyeurism is a problem. That's why it's been a crime going back to, 1800s. And it's an issue, and technology today kind of brings it to a new level. I don't know what the prevalence rate of it is, but we're not immune from it. We're just not immune from it.
Right. And I would say, I do this to my house. We just did it to my house, actually. But I would say you should run a survey on your, and this is tough in a big firehouse, but you should run a survey of every device using your Wi-Fi and IP addresses. It's not hard to do. You can label everyone. Once you do it the first time, you get to label it what it is, so that anything that's not identified, and again, it's a free program you could download. It just tells you every device using your Wi-Fi. So just get it. And look, your printers and photocopiers and computers are all going to be on there. But as soon as you label them, it's easy to see what's not there. And I think that's an important step to protect the rights of everybody, and to tell everybody, listen, you put something on our Wi-Fi, we're going to see it.
Yeah.
Okay. And as I said, we just did that to my house. It was, you'd be surprised what comes up. Sometimes your neighbors have connected and you don't realize, you can't identify certain things. Apparently our refrigerator too. So, okay. Let's talk about Albany. This is a longer case. I'm going to make it not as complicated unless you want to add something, but there's a really important, lesson from this case that I think many of the viewers are faced with. And that question is, or the issue is, what do I do when we have somebody who's in a protected class, right? And we know is going to scream, I've done nothing wrong. You're terminating, injuring, whatever, me based on I'm a protected class. Yet they've done something wrong. They've actually done something wrong. And this is that case. And this is the case I say, listen, if you've actually investigated, documented, and have come to a neutral decision, we'll get into the facts in a second, but have come to a neutral decision about why someone should be disciplined, demoted, or in this case, not promoted, et cetera, and it's not related to a protected class, race, gender ID, all that, then you shouldn't be afraid to make the decision, right? As long as you're making the decision and can prove you're making the decision based on neutral, right? Racially, gender, et cetera, neutral reasons, you should be okay. And here is the classic case. It's also the classic case to show you're not going to stop lawsuits, right? So here we have a guy who's a captain with the city of Albany. I'm going to summarize this, and you can expand any way you want. But this is a decision, by the way. So this is based on the court's findings and holdings, findings of fact and holdings of law. And so the findings were, this guy who's a captain was off duty, was caught on camera, covered with feces, presumably his own, was apparently drunk and not fully dressed, and becomes the subject of police involvement. Let me just throw in the other side of this, that his contention is, number one, he wasn't covered with feces, but number two, that this was a diabetic episode. Right. So that was his position on this. And hypothermic, I think, right? Diabetic and hypothermic. Yes, I'm sorry. Yes, hypothermic. Yeah. Well, diabetes leading to the hypothermia. Right. So he states, well, I was out of my mind. And what he says is, and this is important, I didn't look at the decision exactly to see if they cited the Rehab Act, but no, they didn't. We'll certainly talk about it. He claims he's a alcoholic, right? And that's a disability or perceived disability. He was perceived as having a disability, right? Right. And it would be, except that even the Federal Rehabilitation Act, which says that you can't discriminate against recovering drug and alcohol users, recovering means not using. And here the Rehab Act would not have protected him because he was allegedly drunk. Right. Not allegedly, he was, right? Now that we have a court finding that he was, I think, intoxicated. But in any event, so he's claiming on the one hand, I have a disability. So what happens is the department rescinds his ability to be promoted and promotes the second person on the list. And the court does a favor, I think, to all viewers here, because he said, listen, if they basically hear what I said, right? If you treat them just for what they did and not for any disability or anything else, you're going to be okay. Don't make a decision based on any protected class. Here, the judge throws out the idea of alcoholism is a protected class here because he's not recovering. He's actually drunk or appears to be drunk. And the judge found it was alcohol induced. I think it was right outside a bar, wasn't he? I could be wrong on that. But
I think it was outside of Dunkin' Donuts.
Oh, okay. Yeah, I wasn't sure. It was at Dunkin' Donuts. Well, he was exposing himself at a Dunkin' Donuts while off duty.
Well, yeah, it wasn't. He had his pants were down, but he had his underwear on. So,
okay. So partial exposure. In any event, he becomes subject of off-duty issues. The fire department has a policy on this, and they don't demote him from captain. They simply don't promote him to the assistant or to the battalion chief. And he did not receive any change in compensation or really any discipline. Frankly, they treated him a lot more favorably than I would have. They just said he's not the right person to be in the position of a chief's level position. So they rescind it. But I like this, I'll just say again, because if you have, and it's funny, these all tie together now. If you have a legitimate reason to take action, then you've got a legitimate reason. Don't be afraid.
Yeah, it is a little bit complicated. I find it a little complicated, and I think what a lawyer was trying to do was trying to kind of muddy the waters here. But you have, and let's call it the February 1st incident. So that's where this particular thing occurred on February 1st. So we'll call it the February 1st incident. That alone gives the department the ability to do what they did. And I think that's the ruling of the court. What the firefighter's attorney is arguing is that because of that incident, that employee is now regarded as having a disability or being an alcoholic. And they're regarded as, you cannot discriminate against someone because they are regarded as having a disability. So the attorney's trying to say, no, it had nothing to do with the February 1st thing. You're refusing to promote him because you don't feel that he is fit to be an officer because of his medical condition. So trying to tease out that distinction there, but I think you're absolutely right that the court kind of cut through the fog and said, no, this is not because he's regarded as having a disability. It's because of what happened on February 1st.
Right. And I would say that, look, let's totally change the facts, right? So that maybe it helps people understand it. If he really was having hypothermia and a diabetic issue that created this altered mental status, then yes, right, they would have an issue. But I would have gone one step further then and said, well, until you get cleared by your physician, you're not eligible for promotion or anything else anyway, because you obviously have uncontrolled diabetes. I don't know that it ultimately would have helped them long term.
I think it depends on the past practices, and I know there's some civil service issues in there as well. So that was part of it. So,
but to everybody, don't be afraid to take the right action based on the right reason.
Yeah.
Right. And again, because we could note the Rehab Act, even though not an issue here, right, which they should have raised, frankly. Well, no, because they denied it was alcoholism. So they wouldn't have raised it anyway because they didn't, right? I think they denied, even though the court found otherwise, that he had been drinking, even though he's seen to go into multiple bars from the court decision.
Yeah.
Okay.
And he apparently admitted to that.
Oh, well, it's never helpful. And by the way, your failure to control your diabetes, even if true, caused by drinking, is your own problem. And so, okay. But I find that really, I think that's a standout case, for a lot of reasons, but mostly because I can't tell you how many calls I get. Yeah, but if we do this, they're going to sue. If we do this, they're going to claim this. And my response always is that any factor? Is it any factor, even 1% of your factor of your decision? And if they say no, it's because, well, okay, then don't be afraid. But if you're calling me saying you're afraid, let's just make sure you don't have a legitimate reason to be afraid.
Right. Or if you're calling me because this guy has filed complaints in the past and you want to get rid of him, or you don't want to see him as a chief, that's a whole different story as well. Kind of taking us back to the first case.
First one. Yep,
right.
Absolutely. Okay. Ties nicely together. Let's go to the city of Columbus. They've settled a sexual harassment suit. And this is a little different. Again, we don't know anything. It's a settlement. we just know what was alleged. And people settle for all sorts of reasons. It's cheaper sometimes. They just want to avoid the headache of going to the lawsuit. Doesn't mean they're guilty. Doesn't mean they're not guilty. It just means they thought it was better to settle than not. It's the only thing that means. So here we have the city of Columbus who agreed to settle a sexual harassment suit. It was brought by one of their paid city firefighters. And this was over treatment she allegedly received while at the fire academy in 2019. And here we have a battalion chief, allegedly, who was in charge of the academy, and who was a named defendant in the suit. He was accused of attempting to coerce sexual favors from the victim. Now, look, when you have one person coming forward, maybe you're going to fight it. He said, she said. But what happens is that multiple people, I think 3 additional female employees came forward, and now it starts to become a little tougher to defend, saying there's 3 she says or 4 she says to my he said. And many of them have come forward now saying that chief made sexually inappropriate comments to them. So interesting here, right? I think the city agreed. It sounds like the city agreed because they refused to provide him a defense. They picked up the $225,000 of the $250,000. They kind of had to. They're his employer, so they're de facto responsible for his supervisor's actions. But they refused to pay for legal counsel for him, which I don't know whether I agree with that or not from a tactical perspective, guilty or not, but they refused to provide him with legal counsel. Just so people know, in many states, it's the law that when they declare a conflict, they have to provide you with legal counsel. In New York, they would have had to provide legal counsel here. Whether you agree with them or not, it doesn't matter. You still, that's the conflict. You still have to provide counsel. So I guess in the city of Columbus, they don't have to.
Well, very often, I think there's a politically correct aspect to that they don't want to be paying to defend someone who they feel has committed sexual harassment. So there's a political, you want to look like you're doing the right thing. The problem is, and even as perfect example is here where he had to pay $25,000, but the taxpayers are paying the rest of it. So leave him out. We went through this with the Kansas City case. When you say, well, what you did was so bad, we're not going to provide you with representation. Well, guess what? The taxpayers have to pay. So, I think you're better off providing the legal representation, and you just have to deal with the optics of that, separate from unnecessarily creating liability for the taxpayers.
And look, lawyers are capable of saying, I agree my client's wrong, but maybe shouldn't have to pay as much because, they can argue it was one comment, it was one time, it was in past. I mean, there's a lot, I'm not justifying comments, but there's a lot of mitigating circumstances. You can still be guilty of having made the comments, but maybe it wasn't treated maybe there's another side or something that lessens the damages that could have then helped the city in its settlement. But I'm assuming they just want to say, let's get the money paid, let's get us out of the press, except for Curt and Brad, and then, move on. And maybe that's better sometimes to do. In any event, everyone settled, so they must be good.
All right.
And then you jumped the pond, so to speak.
Yeah. Well, I think it's worth discussing, but go ahead.
Well, you know more on it than I do. That the summary I'll give is simply that Her Majesty, England, has decided that these are going to be my words, fire department is infested with bullying, harassment, discrimination, and that it's widespread in the 44 fire service organizations. And that kudos, right? Because you've got to admit you have a problem before you can solve it. We all know this isn't unique to any country. This is a fire service problem and a lot of other entities, but we deal with the fire service. And I think we do have a discrimination, harassment, bullying issue. Otherwise, half of our topics would be gone, or according to you, 70% of our topics would be gone.
No doubt. But I mean, there's a lot of people who stay at the surface of this problem, and you and I know them, and I don't like to stay at the surface. I want to get into a better understanding of what's driving this. And I think to say that it's toxic male syndrome that's causing this is staying at the surface. that there's a lot more going on. Even some of the cases that we talk about, there's a lot more going on. Different people perceive things differently. And you and I, we talked about this last week. You're a Yankee fan, I'm a Red Sox fan. We see that close play at second base. We perceive it differently. Yeah. There's things that can happen in the firehouse that are perceived differently. And that don't necessarily, with the person who's doing it, isn't necessarily bullying. But that may, and we've got an educational part on that they've got to understand that they may not intend something to be bullying, but it is bullying. Okay. That's why we have lieutenants and captains in the station to supervise. So to manage that, but we've got that perception thing, number one. Number two is, the numbers I've got is roughly 1 in 10 people has a personality disorder. And many of these people are very difficult to live with. If they work for Home Depot, they're difficult people. They work for UPS, they're difficult people. They come to work for us, they're difficult people. When they retire from the fire service, they're going to go on, they're going to be difficult people. And we have a culture that tends to chip away at the rough edges of people in sometimes a very abrasive way. People who are slow to start the housework or shirk their responsibilities or just are saying things that they shouldn't be saying in the fire station. Regardless of race, gender, there are people like that. And when the culture responds to people like that, it can look like bullying. In fact, it very well may be bullying, but it's peer pressure. And so I think my point here is there's a heck of a lot more than just saying it's toxic male syndrome that's causing this problem.
Right. I remember I had a client short to mid while ago, and there was no question that the firefighters were harassing a female. Mm-hmm. And I said, you're going to get in a lot of trouble for this. And they said, but she's not capable of doing the job. What are we supposed to do? We have no way. We know, and I got to tell you, I helped in an evaluation of the person, and the individual was not capable. Had nothing to do with gender or sex. Was not capable. But the firefighters took it upon themselves to try to administer that issue, right? To get the person to quit or to toughen them up. I've heard that one too. We're just trying to make sure you're tough enough to hang with us and be here. We wouldn't pick on you if we didn't like you, all that BS. It's not your job, right? It's not the job of the firefighters to evaluate the skill or competence and then to try to self-remedy what you think the issue is. You report it and you let the fire chief or whatever make that evaluation.
Right. But see, that kind of goes against our culture, because if somebody comes in late, that's going to be fixed at the company level.
Yeah, it is.
The firefighters are going to deal with that, or somebody's not starting or not doing like if there's 10 windows and there's 5 people and everybody's doing 2 windows. Well, if you decide you're only going to do half of one, there's going to be peer pressure put on you to say, hey, why am I doing 3 and you're doing half of one? Right. That's not fair. So the whole deal of fairness, a lot of that is dealt with on a company level. But when a person's in a protected class or a person with a personality disorder, they're going to perceive it differently. And now all things that are said in the station, little comments, little jokes, little things that happen now get written down and they become part of this. So I really, my concern with this paper is that I hope it was looking at all of the issues, not just looking at the surface. Because there's an awful lot more, and that nothing that I said should indicate that I think there's no sexual harassment or race discrimination. There is clearly sexual harassment going on. There's clearly race discrimination going on, but that's part of the story. And I think if I ever went for a PhD in psychology, what I'd want to look at, kind of connecting the law, is what percentage of the cases that we're seeing have some sort of a disordered person involved, whether it's the perpetrator or whether it's the victim, the person who's claiming victim status, and how much of it is really too well-adjusted people. And I really don't think well-adjusted people end up in a lot of these types of problems that we have. There's either the perpetrator has an issue or the victim has an issue, and trying to tease it all out, it can be very, very complicated.
Yeah, and I will share as I'm listening to you a thought I have. There aren't a lot of jobs either in or out of emergency services, right? If you're a salesperson, if you're whatever, there aren't a lot of team jobs like the fire service where you can't move hose without two people. You can't throw a ladder or a big ladder without two people. You can't go into a structure without two people, right? There aren't a lot of jobs where teamwork is required to be safe and effective. You could have a salesperson who's not great, right? And we'll just badmouth them behind their back, but we don't feel the need to correct them because it doesn't personally affect us. Mm-hmm. But in the fire service, unlike police, somewhat like EMS, you need two people, but unlike police in some circumstances where most cops are in single cop cars or on the beat, the fire service requires that teamwork. So when somebody's letting the rest of the team down in a way that makes them feel like, boy, you're lazy in the firehouse, you're going to be lazy in the fire ground. And I always say what happens in the firehouse is a direct reflection of what happens on the fire ground and vice versa. All right. I don't want you lazy there. I can't allow you to be lazy here. So the company thinks, the members think they've got to correct it. Unfortunately, and they'll do that through comments and et cetera, but
nicknames,
nicknames, teddy bears put in a bad location, harassment, whatever it is, to try to self-correct somebody's bad behavior. And while your goal may be correct, it's not your job. It's up to the lieutenant to sit down, document it in writing, correct it through verbal instructions and a further evaluation. Mm-hmm. But if you give any person the chance to come up with a reason why you are treating them badly, they will find a reason. And one easy one is, here, you perceive me to have a disability. How do you fight that? Right? No, you don't. Well, I was drooling one day, so you perceive me to have a stroke, or, whatever it is, it's not hard. And everybody is some religion. Everybody is some gender and sex. Everybody is some part of the LGBTQ plus. There's so much that everybody is one of something. You're just giving them a reason. Just stop self-handling it. Go to your lieutenant, and lieutenants and captains grow up and put it in writing and document and counsel and do all the things you're supposed to do.
Right. And we've got to get good training for those company officers, too, because all too often they're very proficient at a structure fire or hazmat or any of the types of incidents that, we commonly have. But when it comes to HR and documenting and managing the problem, they kind of think of themselves as just maybe a senior firefighter. But dealing with a difficult person is not really part of their responsibilities. And that's, I think, contributes to a lot of the litigation that we're seeing. If we can get well-trained officers that know what to do when they have a problem employee, they know how to handle it, know how to document it. And a while back, we documented that Denver case where Denver documented everything about a particular candidate.
Yeah.
And we've got to get to the point where, the bell curve, most firefighters or most fire departments have the ability to document those types of things in a way that's not discriminatory. You're not going after somebody, but you're documenting it. And at some point, it's going to be obvious what the problem is.
And look, if you don't document it, as you just said, you can bet they are. So they're documenting everything you've said or done and the date. And people should, I just had a conversation about an hour ago with a client. And they were told, I talked to somebody from the state and they said this. I said, put it in writing because that's going to be my first exhibit. And the comment was, well, can't I provide you an affidavit or something later? I said, it's hard to explain the power and believability, credibility of a contemporaneous document. I just talked to you. I just got off the phone with you at this time. I'm sending you this letter. You didn't refute it. And exhibit A. And that is the power of Denver. That is the power of coterminous, immediate, prompt, complete, neutral, reports. And I'm just having, I hope people will email you after I say this, whether they like this idea or not, but shouldn't you and I run a captains and lieutenants or junior officer training, program, maybe 3 hours long? And I'm thinking we could be talking about everything like here to supervising others, to family medical leave, to, there's so many things, to people calling in sick time, people, right? How do you react? What do you do to both protect yourself and your department? And we could come up with easily 3 hours of substantive recommendations.
Well, we've been talking about doing the HR conference, and I think that could be one component of the HR conference, certainly. And I've got a couple of little classes that I do sort of in that area where we run through common scenarios that company officers are faced with, and what do you do? Like, and not just don't give me the blackboard answer, the chalkboard answer, or the classroom answer. Give me, like, honestly, what are you going to do? This happens. What are you going to say to the firefighter? What are you going to say to the other firefighters?
We're going to harass the crap out of them.
Well, and we kind of run through it that way. So
yeah, I think it'd be a great addition. It'd be a great training that people need. Yeah. So anyway, with that was
we're gonna get going on that HR conference. I really want to get that off the ground. We get your FMLA, we get the FLSA, we get just
discipline, investigation,
and
my God, we could do so much, so much. So very good.
All right. Well, that's going to do it for another edition of Fire Law Roundup. And I want to again express my gratitude to the folks who have subscribed. We have hit our benchmark of 1,000 subscribers, so we're really excited about that, and we're looking forward to the future. Now, hopefully, we'll get more coverage. We do need another few hundred hours there on YouTube, but we're almost there. We're chipping on 18. So
perfect.
All right. And that'll do it for another edition of Fire Law.